How to orally apply for your client's bail in court. Bail application. You can also do it orally. So this is what I will be talking about in this video. My name is Mary and I'm a practicing lawyer in Nigeria. On this YouTube channel, I share videos to educate the general public. I share videos for lawyers as well, particularly the new weeks. So if this is your first time on my YouTube channel, please do well to click on the subscribe button. Also like this video and share this video with anyone that you think this video will be helpful. They'll find this video helpful. And if you're a returning subscriber, I do love you. Thank you so much for always coming back to watch my videos. So let's talk about bail. Bail, we have three types of bail. We have the police bail, which we can also say bail at the AFCC, NDLA, all those law enforcement agency. That is the first type of bail. We also have bail, court bail. That is when a matter is being, when an accused person, a defendant, is being arraigned before the courts, then you apply for another bail. The bail at the police or at the EFCC or at the NDLA, by that time that bail will terminate. Excuse me. So then you need to apply for another bail in the courts. Okay. Excuse me. And the third type of bail is bail pending appeal. Let me quickly mention that bail is just a temporary release of a person, of an accused person. It doesn't mean the person has the liberty forever. Pending the determination of that case. That is what, or probably pending the determination of the appeal. That is what bail is basically for, okay? That's liberty because there is a presumption of innocence. So what if after the conclusion of the case, that person is found innocent? If you put that person behind the bar to be so unfair to that person. So there are certain offenses that are actually bailable. The capital offenses are just like murder, manslaughter, armed robbery, those offenses and the likes like that. Those offenses you don't get bail. Although in some armed robbery cases, some judges obliged the accused person bail. And for me, I think that is quite impressive because prosecutors sometimes they'll just draft charge with due respect to them, not all of them. They'll just draft charge and before you know it, they'll term it armed robbery. It could be as little as stealing, but they will term it as armed robbery. So if as a judge, while perusing the charge and the proof of evidence, you realize that though the judge needs to wait till when the prosecution will prove the case beyond reasonable doubt before the judge can say there is a cause of action, or not even the word cause of action, whether the prosecution actually have a case or not. But by the proof of evidence, one can also know if it's actually a case of armed robbery or a case of robbery or a case of stealing. So ordinarily, armed robbery are offenses is one of the offenses that ought not to be bailable. But if the judge, in his own opinion, can see that by the proof of evidence, there is nothing substantial enough to say that there is a case of armed robbery, I think in such situations, some judges do oblige the accused person bail pending the determination of the case. So I've been able to mention what bail is all about and the three types of bail that we have. I also need to mention that bail oftentimes needs to be written. That is, you need to make a formal application. It needs to be in writing. It needs to be a formal application. If you're making a bail application at the High Court or Court of Appeal, you need to make sure that application is in black and white. You need to file it. But at the magistrate courts, also area courts, I think of recent the area courts. Area courts is familiar in the north. So the Grand Cadi already made a statement that the area court should stop having to stop entertaining criminal matters. So I still don't know whether there'll be a review of that, but basically criminal matters at the area court and district courts, magistrate courts, you can make an oral application. So I have a video where I explained how you can move your bail application in court. That is in case of Court of Appeal, High Court, because you need to file a process. There is a motion that you need to file. How will you move that motion? It's quite similar to moving of a motion. Do you understand? Except if you just want to elaborate, it's basically moving of a motion. But I made a separate video on how to move a motion and how to move a motion for bail. So in a situation whereby your client, the accused person, is being arraigned, sometimes they can, the police, the EFCC, Many of them can make some arrest overnight. We do call them overnight cases, and the next day they're already proceeding to court. You don't have time to file a bail application. It is not even necessary. It is not necessary. It is not necessary that you file a bail application. So you can just make an horror application. The time for you to make your horror application is immediately after arraignment. Arraignment means that is the period that the accused person, the charge will be read to the accused person, or the FIR will be read to the accused person. The accused person will take his or her plea. That is, I'm guilty, I'm not guilty. After that, that is when you need to make your application for bail. So when you make an application for bail, you can as well tell the courts to order the prosecution to serve on you the proof of charges and proof of evidence if they are yet to do that. But after the plea, the next thing is for the prosecution to be requesting for a date for hearing. So before the prosecution make that application, because at that point it means the case for that day will soon be done because you are already picking it. Immediately after the plea, after your client's plea, make sure you inform your clients before arraignment that you have to say not guilty. In most cases, you have to say not guilty, except if you're doing a plea bargain of the thing. So then after the plea, make sure you make your oral application for bail. You have to get up immediately. Even if the prosecution wants to get up, because they never can say the prosecution is about to request for a date for hearing. So if the prosecution is just insisting like, oh, I need to just tell the court something, after it makes the after it make if you cannot make your own application immediately after your client's plea, that is the accused person's plea, probably you don't have that time, or probably the prosecution was already up. Just make sure that immediately prosecution is done, or probably before you even finish, you can just tell the court that, my lord, or your honor, or your worship, then the court can say you should hold on or you should hold on. And just make sure before the court starts writing anything like picking a date and things like that, because I need to just mention this, probably there are new wigs watching this video and you feel because the prosecution is one elderly man, you won't allow him to talk first. You need to make your application, your oral application for bail after your clients, after the accused person's plea. Okay, so what are the things you need to say? In as much as you don't have a process before you that you need to probably adopt or something, what are the things you need to say? There are basically, let me say, 3 to 4 things, except if there are more things to your facts, to the fact of your case that you want to say. The first thing is the presumption of innocence. So you tell the court, my lord, we humbly apply for bail for the accused person, because so we should go ahead. While you're saying it, to make sure you take it slowly so that the court can capture everything you'll be saying. So you tell the court, my lord, based on the presumption of innocence according to the Constitution, the accused person is still presumed innocent until the contrary is proven. For that reason, we are begging your worship, or we are pleading or praying, not begging, to grant the accused person to bail in the most lenient terms. Don't forget that word, because some courts might just want to give um heavy conditions. Okay. Also, another thing you could say is the offense is a billable offense. Try and know whether the offense is billable or not. But oftentimes, offenses at the magistrate court where you can make oral application, oftentimes, let me say most time, all times rather, they are billable offenses. Okay, so the offense that the accused person is standing trial for is a billable offense. The third thing you can also mention is if the accused person has been in detention for a while, you can try and make sure you can say, okay, the accused person has been in detention for about a month. You are not saying a month from just your head. You need to be sure if that fact is true. Like one that I did, the accused person was in detention for about 3 months. So things like that, you can actually use that to rub the mind of the judge to consider your application for bail, because they have discretion whether to grant or to deny your application for bail. Okay, so that is another point you can mention. The duration whereby the person has been detained. Also, another thing you could say is the prosecution has concluded the investigation, hence the arraignment. You know, if prosecution are not done with investigation, oftentimes they don't arraign when they are not done with investigation. So you can also mention that some judges will be like, oh no, how did you know investigation is not still in process? But there is no harm in saying that. Okay, it will be for the prosecution to not get up and say whether that is true or not. But you can just add that prosecution are done with their investigation, hence the arraignment. You won't just say prosecution are done with their investigation, because the court will be like, how did you know that they are done? But you say your reason for saying they are done with investigation is because of the arraignment. Because oftentimes they don't arraign before when they are not done with investigations. That is, the case is still in process. They are still investigating. Are they sure that they have enough proof of evidence and everything to just charge this person? So you can mention that as well. The fifth thing I feel you can mention is if the accused person has any medical challenges, you can mention that as well. Like, my lord, if you have a proof, you can show the court. If it's a government hospital, so we can tell the court that the accused person has maybe is asthmatic or hypertensive. I'm not saying you should tell lies, but I'm saying you can ask. Those are the things you can ask. You can ask your clients before the court starts sitting or before the matter is being called that health-wise, do you have any problem? If the person says no, you don't need to mention that to the court. So these are the things that you just say to the court. You don't need to start being afraid or something like you did not prepare for the case. Or application for bail is very, very much possible, is acceptable at the lower courts. Okay, so that is basically what I want to share with you in this video. Please do not forget to drop a comment, like this video, and also share this video. Thank you so much, and I will see you in another video.